webinar, that's how we got. So we thought it's only if more people can come in, they can take advantage of what, because it's an important subject. All of us are already know that the FTA has been implemented, and the government has also taken all the steps on notifying the procedures, regulations, and whatever else is to be done. I'm sure some of you may have tried to ship your goods. Some already have shipped it, and some are probably in the process. So all the issues related to how you went out and any issues that you face when the implementation begins will be taken up today. So all of you can raise your issues, queries, doubts, so that we take the maximum advantage of this FTA, which is landmark. We've been trying for this for a long time, the Indo-UK FTA. So I think, shall we start? Yeah. People will start joining in. Thank you very much, everyone. Good afternoon to all of you. I welcome you all to this important webinar on India-UK CETA, rules of origin, custom compliance, and sectoral opportunities. So there are three aspects to it. All these are very important. So therefore, the rules of origin must be understood clearly. The custom compliances must also be there. And you must also know that there is a self-certification process which has been put into place for a certificate of origin. So all those issues will come up, and you must know how to operate those so that you get a very smooth passage of your goods. At the outset, I would like to thank Lakshmikumaran and Sridharan Attorneys for partnering with TEXPROCIL for today's program. And L&S, as they are known, are a very well-known law firm, and they have pioneered the work in trade-related matters. I also warmly welcome the participation and support of FICCI for the season, as we already recognize Mr. Mukhi. Deepak Mukhi is the director of FICCI in the Maharashtra Council and is the leading face of FICCI in the Western region for policy advocacy, government affairs, international collaboration, trade promotion, and many other things. So he is very actively involved in various aspects. Friends, the Indo-UK Comprehensive Economic and Trade Agreement represents an important milestone in the economic partnership between India and UK. All of us, please kindly mute yourself. It will help us to understand and listen to each other. The foundation for this agreement was laid, as you might well know, through the India-UK Enhanced Trade Partnership and Roadmap 2030 in May 2021. That's how the foundation came, and it took about 5 years for the agreement. So after 14 rounds of negotiations, the agreement was concluded on 6th May 2025 and formally signed in London on 24th of July 2024. Following the completion of the required internal procedures and ratification by both the countries, the India-UK CETA entered into force from 15th of July 2026. That is last month. It entered into force. This agreement is landmark for us because it provided immediate duty-free access to the UK market for approximately 99% of India's exports. So it was a front-loaded agreement, totally front-loaded, covering nearly the entire value of India's merchandise trade with United Kingdom. So not only textiles, but the entire merchandise exports was covered under this and got on day one the benefit of a zero duty access. For textiles and clothing, where UK import duties earlier went up to 12%, or it was 9.6% for home textiles and garments if you applied the 20% GSP, the elimination of tariffs can substantially improve the price competitiveness of Indian exports. And all of you know that UK has been a very old market for India. Early 70s, our export itself began when fabrics were getting exported to the UK market. And there were a lot of people from which a lot of later on the quotas came up and so many other things happened in the industry. However, it needs to be noted that tariff elimination by itself does not automatically guarantee preferential market access. So this is a very important point. You must all note, okay, I got tariff access, I'm okay, I'm fine, and my goods will go in, but not necessarily. So then that's where today's webinar becomes very, very important. To claim the benefits available under the CETA, exporters must ensure that their products satisfy the prescribed rules of origin. That is the first point. They must also maintain appropriate production, sourcing, value addition, and commercial documentation to substantiate the originating status of the goods. So these, as you go forward, you will have to keep proper records of how you are eligible for the benefits of the zero duty through the original rules of origin. Recognizing the importance of these requirements, as you would be, if you have been reading the TEXPROCIL, post, has been regularly updating. In fact, we in the council have been regularly updating people on the operationalization of the agreement. Constantly, our team has been sending out messages, giving details. The council circulated the notification prescribing the rules of origin under the India-UK CTA. We have already done that. We also requested shipment information from members and issued an advisory concerning consignments that were already in transit. In fact, there was an issue, goods were in transit on 15th of July. So what happens when they reach there? What treatment will they get? And some were been custom cleared, yet to board the vessel. So what happens to them? So all these were the last mile issues, which probably we have been able to clarify to the satisfaction of most of our members. Further, TEXPROCIL has been informing that electronic filing and issuance of preferential certificates of origin through the Trade Connect e-platform. Please note that the preferential certificates of origin will be electronically filed through the Trade Connect platform of the Ministry of Commerce. CBIC guidelines we have also forwarded concerning self-certification and original declarations. So there are detailed guidelines that the government has issued. Operationalization of preferential customs duties under the agreement and provisions related to retrospective and delayed claims of preferential tariff benefits. So these are all some critical areas, especially when it comes to the transition, when one, what shall I say, era ends and the other one begins. The duty era ends and the duty-free era begins. So there could be some issues which come in the transition period. Friends, the rules of origin are particularly important for the textile sector because textile manufacturing, as you all know, involves several stages, beginning with fiber, spinning, weaving or knitting, followed by processing, dyeing, finishing, and the manufacture of made-ups or garments. So all these processes are there, which need to be, you need to ensure that the rules of origin, the way they have been drafted or constructed, they take into account all these aspects when the rule is formulated and finalized. So today's webinar has therefore been designed to address both the legal requirements and the practical implementation challenges. So we are more interested in the practical implementation, for the legal is already there. So there are already lawyers like L&S who will help you with the legal part of it. But the practical thing needs to be understood by all those who are operating the agreement and all those who are exporting. So that will also be clarified, and we are really grateful to the team of young two ladies who will run us through their presentation. The session will explain the rules that I mentioned and the procedures to be followed. For importers claiming preferential treatment on the basis of self-certified origin, because this is a novel thing which has been introduced, self-certified certificate of origin, which you certify in your own office. So otherwise, you come to an agency and get it done. Our experts will discuss the precautions that you should take, the document that should be maintained, and the safeguards required to minimize custom queries. Very often, but they may not be able to recognize, or they may not be willing to acknowledge the fact that there is this and it's been issued by your office. So there are a lot of measures to be kept in mind. So you're advised to listen carefully, and our young team will be able to navigate through all these rules, regulations, and procedures. Now let me introduce the two speakers for today afternoon. One is Ms. Nupur Maheshwari. She is the executive partner at Lakshmikumaran Sridharan. She has more than 18 years of experience in indirect taxation, cross-border trade, and customs law. Her areas of expertise include custom classification and valuation, pre-trade agreements and rules of origin, export controls, foreign trade policy, SEZ regulation, post-clearance audits, and custom litigation. So therefore, she has end-to-end on the customs side. She is able to answer all the queries. She has advised several leading Indian and multinational companies, including business operating in the textile sector as well. Ms. Disha Bhandari is partner at Lakshmikumaran Sridharan, the other speaker, and has been associated with the firm since 2012. She has also been there for the last 14 years. Her practice includes, again, customs, international trade, and WTO laws. She has extensive experience in tariff classification, valuation, duty exemptions, and custom-related regulatory matters. All these issues become equally important when it comes to the implementation of the Indo-UK FTA, because there is a customs on our side and there is a customs and border control on the UK side. She has represented clients, as we found, before departmental and judicial forums, and is also a qualified company secretary and an advocate on record of the Supreme Court of India. So we have a very, very, a panel which is absolutely, what shall I say, sterling backgrounds, qualifications, experience. So I encourage all of you present on this call to take advantage of this and ask your queries, questions. It will be a good idea. Once they finish the presentation, you can sort of post your questions on the chat box or raise your hand. We'll be happy to sort of, answer those queries. And later on, what will also happen is this presentation, with their permission, we will put it on our website. So all of you are also advised to visit the TEXPROCIL website and have a look at this. So with these few words, I would also say Mr. Mukhi from FICCI will, at the end of it, sum it up and also propose a vote of thanks, because FICCI is equally keen that the industry at large benefits with from these bilateral agreements. So with these few words, I thank you very much. And I now invite Ms. Nupur Maheshwari and Ms. Disha Bhandari to take the floor and start the presentation. Over to you, young ladies. Please go ahead.
Thank you so much. So I hope I'm audible to everyone.
Yeah.
Great. A very good afternoon to all of you. And first of all, I would like to thank TEXPROCIL, FICCI, and Mr. Mukhi for giving us this opportunity today. I think FTAs today are, driving trade globally, and it's one of the most important topics when we are dealing with cross-border trade. And considering that India has been proactively entering into so many free trade agreements, there is a lot of business opportunities for all the importers and exporters in India. And that's why, each time it becomes very, very important to understand what are the nuances in the new free trade agreements that India is entering into. Because traditionally, an FTA used to be an agreement purely in relation to import of goods and the origin criteria which the importer or the exporter was required to fulfill in order to claim the free trade agreement benefit. But today, when we look at the FTAs, the scope of the FTAs has really widened. It's not just about goods, it's also about services, it's about market access, it's about creating job opportunities. So therefore, there's a whole lot of gamut of activities which are now governed through the FTAs, and that's why it's very important that we understand the FTAs, how these FTAs work in relation to our businesses, and so that we can make the most out of it. So I hope we have an enriching session today, and would request that whatever queries you have on the discussions that we are going to have today, please feel free to raise questions, and we'll be happy to answer them at the end of the session. So with that, I think I'll just begin the topic, which is UK-India Comprehensive Economic and Trade Agreement. So before we discuss the FTA in detail, I think it's important to understand a snapshot of the trade between India and UK, and that will also help us to understand why there was a need for an FTA between the two countries. So see, UK is amongst the top 5 export destinations for India. And as per the statistics available till November 2025, more than 15.39 billions of trade had undertaken. Exports were made by India to the UK. And the major items that are exported by India to the UK are exports of heavy machinery, gems and jewelry, and also pharma products, and of course textile. So textile falls within the fifth category of the exports that are being made by India to the UK. Similarly, on the import side also, India has been heavily importing from the United Kingdom. And some of the sectors where, we import from the UK are again boilers and nuclear reactors, heavy machinery, which is heavy machinery, then semi-precious stones, beverages, spirits, vinegars, and a lot of metals, copper, aluminium, steel, etc. So, as we all know, India is one of the fastest growing economy. And if we go by the vision that our Prime Minister, Mr. Narendra Modi, had for the nation, he has actually come up with a 25-year plan for India where he wants that the per capita of income of India grows by 9x. He is also promoting the largest and the youngest working population that we have. And India is being projected as a China plus one counterpart for all the countries worldwide. And with that thought, he has also been entering into free trade agreements with different countries. Some of the recent ones being India, EFTA, India, EU, India, UK, and of course, we also know that negotiations are going around for India, US free trade agreement. Now, before we, Preeti, if you could go back to the slide relating to textiles. So, before I talk about free trade agreements, I would also like to show some statistics on the major textile categories. We saw that as per the data available, the maximum exports from India were under Chapter 52, Chapter 58, 56, 59, and 60 under the textile category. And the cotton fiber, cotton yarn, cotton fabrics, and cotton home textile made-ups are the products which are exported the most from India to the UK. Preeti, you could move to the next slide. Now, India is amongst the top 6 countries which are exporting the textiles to the UK. And roughly 14% of our global export of fabrics are covered under 5208 for the UK, which is fabrics for cotton, woven fabrics for cotton. Again, we are the 6th exporter of textiles to UK. And therefore, with the free trade agreements and with the tariff duties becoming nil for the textile sector, there is much more opportunity available now. And the free trade agreement is likely to give an impetus to the trade which is already going on between the two nations. Now, let us understand what is a free trade agreement. So, if you all would know, we have an organization called the World Trade Center. The World Trade Organization, WTO, as we all know, is the global institution which governs trade between all the nations in the world. The purpose of the organization is to reduce any obstacles for free movement of trade, to ensure that there is a level playing field for all the nations. And it also provides a forum where different countries can enter into agreements. They can implement such agreements, and in case there is a dispute between the countries, they can also settle those disputes through a dispute resolution mechanism provided by the World Trade Organization, WTO. Now, WTO generally, all of this, the whole purpose, it works on the GATT principle of most favored nations, which means effectively that equal treatment should be given to all WTO members in trade. So therefore, effectively, when there is a trade happening between two WTO member nations, they have to ensure that they are given same kind of benefits in trade. If a lower duty is being offered to, say, nation A, similar benefit should be offered to nation B. A deviation from this most favored nation principle comes in the form of free trade agreements. Free trade agreements, why would I call it an exception? Because WTO recognizes that there could be regional trade agreements between different countries who are members of WTO. And through these regional agreements, these selected countries can provide a preferential treatment to each other, which is they can trade in a better way than they're trading with any other WTO member. So therefore, free trade agreement is an exception to the most favored nation concept, which is generally followed by the World Trade Organization. Keeping this intent in mind, different countries have been entering into free trade agreements. And as we discussed, India has also entered into several free trade agreements. Specifically, in the last 4-5 years, we've seen that all the trade negotiations in relation to the free trade agreements that were happening over the years have been concluded and new agreements have been entered into. So now let us understand some of the highlights and the timelines for the India-UK Comprehensive Economic Trade Agreement. So as we know, the agreement was uh, notified on 14th July 2026. In fact, the agreement was signed in 2025, July 25. It was notified in 26. The rules of origin again were notified on 3rd July 2026, and the agreement came into effect from 15th July 2026. As pointed out by our hosts, the agreement has vast potentials for the exporters from India, because more than 99% of the tariff items that are being exported by India to the UK have been granted some sort of duty benefits. For some of the sectors, but in particular textile sector, we know that they have provided very heavy exemptions, and in most of the cases, the duties which were running up to 70% have been slashed down to nil. So therefore, there is a great potential, and now I would request Disha to sort of explain to us what's in the deal, and what are the salient features and what are the precautions that one should keep in mind when we are dealing with the India-UK Free Trade Agreement. Over to you, Disha.
Thank you, ma'am. So, like what ma'am just mentioned, that the India-UK Comprehensive Economic Trade Agreement, as the word suggests or as the word says itself, it's a comprehensive agreement which covers goods, it covers services, it covers investment, digital trade, government procurement, intellectual property, and regulatory cooperation. So, the objective with which this agreement has been entered by both the countries is to enhance just not the bilateral trade, but also to improve market access, to increase the investment flows in both the countries, to strengthen the economic cooperation between India and the UK. Now, having said so, there are, as what can be seen from the screen, that there are many chapters. It's a comprehensive coverage in 30 chapters, and the side letters what's there in this trade agreement. Now, one of them, which is a very important chapter specifically for the importers and exporters, considering trade is involved, is the rules of origin. Now the questions come: what is rules of origin? Now, rules of origin basically they specify the rules or the guidelines, the criterias which goods must satisfy to qualify for preferential tariff treatment. So there are various rules which are there. So you'll have to look at the accumulation, you'll have to have product specific rules, there are some origin certification, there are verification procedures. All of them, they come under the ambit of rules of origin. Now, having said so, I would want you to read the definition which is given under the rules of origin clause, which specifically provides that rules of origin define the conditions under which a good is deemed to be originating and therefore suitable for preferential treatment. Now, the question comes as to why rules of origin is important, or what is this preferential treatment. Now, the benefit of this trade agreement is basically between goods which are originating in two countries. When the goods are originating or they qualify to be originating in India, then they become eligible for preferential treatment in UK. Likewise, in a situation where goods are originating in UK, then they become eligible for a preferential treatment in India. So this is a basically dual side thing. Hence, it becomes very important to understand how how will the country of origin, or how is the origin going to be ascertained, and hence we have rules of origin. Now, this is not the first time that an FTA is having rules of origin. Rules of origin are there across various FTAs. It's a consistent thing. However, they keep changing. So like this new age FTA, which we call the India UK FTA, that has slightly different rules of origin as compared to what were there in the earlier ones, and hence it becomes very important for any importer or exporter to both the countries to ensure that the goods are that the rules are adhered to, and on that basis only the exemption is taken. merely because, say, in past we were exporting to some other countries, say under ASEAN, and taking the benefit of the ASEAN FTA. That should not show that, this, that should not mean to indicate that even this FTA requirement I'm also fulfilling, because you'll have to look at each of the clause specifically for each FTA. Now, for the rules of origin, basically the origin criteria has been divided into 2-3 points. First is something which is called as wholly obtained, or goods which are produced entirely in the territory of one or more of the party. So maybe the illustration could be like minerals, mineral goods, other non-living natural resources, plants, fungi, etc. All of them which are there in that country. Now this is the first point. Now the second is with respect to the ones which are not originating in India or in the UK. So basically, wherever the goods are being manufactured using certain non-originating materials. This non-originating materials could be, say, originated from China. It could be originated from Japan. Let's take a simple illustration that we've got cotton from Egypt. We got cotton from Egypt. We undertook certain manufacturing here in India, and then we exported it to the UK. The question is whether this is an Egyptian originated material or this is an Indian originating material, and whether I am entitled to avail the benefit under the UK FTA. So in this respect, there are certain rules which have been given, and these rules are these are called as product specific rules. Now, product specific rules specifically for textiles are on 2 grounds. The first is where there is change in tariff. The second is value addition criteria. Now, we're going to discuss this in the subsequent slide using certain illustrations. Now, first, like I said, there is the rule of change in tariff. Now, in this situation, let's take an illustration that I imported certain raw materials in the form of raw cotton under Chapter 5201. And thereafter, there were a lot of operations which were undertaken in India. Like we did spinning, weaving, cutting, stitching, and finally, women's shirt, which is classifiable under 6106, was manufactured, and this is being exported to the UK. Now, the question is whether this will qualify to be an Indian original product, or it is going to be or it will qualify to be an Egyptian origin product. So, what is tariff jump is relevant here. Now, tariff jump basically says that the input, the classification which was adopted at the time of input, that should actually have jumped, and the classification of the finished product, that would be different. So in situation where the classification of the inputs and the classification of the finished product is different, this qualifies to be a tariff jump illustration. So in this case, like 55201, there was jump from CTH 5201 to CTH 6106. So this qualifies to be an illustration of tariff jump. Now we'll go to the second point. Now, which is respect to the value. What initially in the slide we discussed is about the value addition criteria. Now there, sorry. Now under the rules, there are basically certain. There is a rule which just
I'll be taking up the rules of origin. I hope I'm audible.
Yes, you are very much audible.
Yes. So under the value addition criteria, there are 2 methods by which you can prove the value addition. First is the build-up method, which is based on the value of originating materials. Second would be the build-down method, which is based on the value of non-originating materials. Now for build-down method also, there are 2 criteria that you could look at, which is the ex-worst price or the FOB price. I will explain this by way of an example. So first method is the build-up method, where you use value of the originating material to calculate how much value addition is undertaken in India. So for example, you have to manufacture a cotton shirt. Now for cotton shirt, you source the cotton fabric, the buttons, label, thread, Now all these total originating materials come up to 30. And at the time of export, the value of this shirt is say 80. Now applying the formula, I will divide the value of the originating materials, which is 30, by total X works price of the shirt at the time of export, which is 80, multiply that by 100, and this is the value addition percentage that I get, which is 37.5%. Now under the FTA, the required value addition is 35%. Now since my value addition is more than the required QVC, which is 35%, I will qualify as an originating material. Alternatively, I might calculate this using a different method, which is the build down method. Now, under the build down method, I will use the value of non-originating material. So in an instance where I have to manufacture men's cotton trousers, I will import certain raw materials for that. So suppose I import zipper from China, then I import the interlining, the pocketing fabric, etc. Now all of that comes up to 35 rupees in value. And at the time of export, my X works price would be 100. Now again, applying the formula, I will first subtract the value of the non-originating material from the total value of the export product, which is 100 minus 35, divide that by 100, and then I get this value, which is 65%, which is again more than the required minimum QVC, which is 40%. Therefore, here also I will qualify as an originating material. Now, in a situation where I'm not able to qualify this threshold, I will not be able to qualify the criteria for value addition.
So just to add here, the build up and the build down method.
Moving on, there are some other criteria
Sorry,
aspects under the
Preeti, I
rules of
just wanted
origin as
to
well.
cover something.
Nupur ma'am, you want to take this portion?
Yes, no, I want to cover something here. So, as we all saw, Preeti just explained the build down and the build up method. Build up
Yes, so
method
there
is
are certain
nothing but
aspects which we need to take care of while we are ascertaining the rules of origin, or while we want to see whether in terms of the valuation or in terms of the tariff jump, whether the requirement is being fulfilled or not. Now, one of them is say cumulation. Now, cumulation, if I can say in simple language, it would mean that if there is any material which is considered as originating in India, and then it is used to make product in the United Kingdom or vice versa, then that material is going to be treated as if it originated in the country where the final product is made. Now, this basically helps the businesses to use inputs both from India as well as UK without losing the FTA benefit. A simple illustration could be that, say, a UK garment manufacturer, he's making a cotton shirt for export to India. Now, the inputs which are used, say there is it's fabric which is coming from which is from India for say around 60 pounds. Then you have buttons which are coming from UK of 10 pounds. Then there is stitching and finishing activity which is undertaken in the UK for say 30 pounds. So the total value of the shirt is going to be 100 pounds. So normally to get FTA benefits, the shirt must basically meet the UK origin requirements. Now under accumulation, the Indian fabric, what was of 60 pounds here, that is going to be treated as if it was originated in the UK while calculating the origin material. Then we have something called as indirect material. Now there is a specific clause under the agreement which deals with indirect materials, and it clearly provides that the indirect materials, they are not going to be considered as originating or non-originating while you are calculating the qualifying value content for ascertaining the valuation. Then we have
Disha.
something like de minimis. Now, under this specifically FTA, the percentage of the de minimis is not same. It varies on the basis of the classification. And
Disha,
for
can you wait? I
specifically
think
for
there are some
textiles,
questions being
the
raised.
percentage is
Disha?
12.5%. So
Disha?
which it specifically provides that in case if your product is falling under chapter 25 to 38, which includes chapter 25 to 98, which includes the textiles chapter also. So in that situation, the value of the non-originating material, it should not exceed to 12.5%. So in such a situation, it's nothing but like a toleration kind of a principle, that you're allowed that even if your product has a non-originating product, non-originating material of 12.5%, it will still qualify to be a originating product. That is in terms of the de minimis rules. Then
Disha, thank you
the
so
other
much.
rules are like,
Can
in
you
case
wait
if
for
there
a
are any
minute, Disha?
accessories, spare
Hello?
parts, and tools,
Am I
they are
audible?
to be classified and presented with the
Yes, you're
goods,
audible. I
and they
think
will
she's
be
not able to
disregarded while
hear.
you're ascertaining the
I understand
valuation
that.
in order to ascertain the classification. Now, Nupur ma'am, what would you want? What would you want to talk about the third country invoicing?
Disha, are we audible to you or not? Hello?
Disha, are we audible?
Ma'am, you're not audible.
Yes, I
Nupur,
think
I
there's
think you can call Disha on her mobile and talk
yes,
to her.
I'll just do that. I think there's some confusion. Just give me a minute, please.
Yeah.
ये जो ग्रीन हाईलाइट होता है ना, इसका मतलब आपका आवाज जा रहा है. But she is not able to.
So see, there are, I understand that I've just called her. We have some questions, but before that, there are some points that I would like to touch upon. And first of all, we are extremely sorry on the technical glitch. I think there is some issue and as a result of which she was not able to hear us. We are rectifying that problem. In the meantime, I'll discuss some of the points. So see, we talked about build up and build down method, and uh, just for everybody's benefit, it's not a new thing. I mean, while we are reading it as build up and build down method, but build up method is nothing but a direct method, which was also there present in other FTAs for calculation of origin criteria. And similarly, build down method is an indirect method of calculating the origin criteria. One of the aspects that one should keep in mind is whether, one may ask that uh, is it possible for me to take both build up and build down method?
मेरा ऑफ है सब ऑफ.
So, Preeti, you are not on mute. So, whether I can claim build up or the build down method at the same time. So for example, in a given year, whether is it possible for me to calculate origin criteria on certain occasions under the build-up method, or where I don't have the data for the originating material, is it possible for me to switch to the build-down method? So just to give everybody an idea, if we see some of the past FTA agreements, and again, I'll take ASEAN agreement as an example for the purposes of this discussion. So if we see the ASEAN Free Trade Agreement, it very clearly states that the importer can exercise only one option at a given point of time, and if one option is exercised for the entire year, he should follow the same option and he should not change the option to another method. In fact, if he wants to change the method, he has to notify the parties in advance, and the notification is required at least prior to 6 months. Uh, because the UK agreement is the recent agreement and there is a lot of thrust on the trade facilitation, no such bar has been created under the UK rules of origin for claiming the calculating the origin criteria. So, in a given year, an importer or an exporter can also follow a built-up method, or he may choose to follow a build-down method also, no problem at all. However, practically, it is our view that it is always good to go for one particular method, at least for a particular period of time, so that you are consistent with your declarations, and there is also some amount of certainty, because we'll be discussing that in great detail later, that how new ways of declaring the origin criteria, of confirming the origin criteria, have been provided through this free trade agreement. And if we keep changing our origin declarations on the basis, okay, we don't have build up method, or we don't have value of originating material, so let's switch to non-originating values, or if we have don't have non-originating values, then let's switch to originating values, it can only create confusion with the customs, and your imports may be subject to greater scrutiny. So, as while there is no bar, our suggestion will be that stick to one method, at least for a sustainable period of time, effectively a year or so that you have that certainty, so that you have that consistency, and your claims for the free trade agreement are questioned less by the respective customs authorities. One more thing I wanted to check, and Disha, that's a question to you. You mentioned that of course, you don't include the value of non-originating material for determining the origin criteria. I mean, you will subtract that value when you are calculating the value add. Now, let us take a situation where I imported a non-originating material, and the non-originating material was subjected to certain processes by me. After subjecting it to certain processes, certain manufacturing activities, the material becomes an originating material, okay? Because I am satisfying the product specific rules and other rules under the rules of origin agreement. Now I use this material, intermediate material, in turn for the purposes of manufacturing a finished product. Then what happens? Whether it becomes an originating material for me, or it still continues to be a non-originating material for me.
If you fulfill in the illustration which you just said, that if you fulfill the requirement that the non-originating material has become originating, then all the consequences which are there in terms, or all the implications which are there in terms of originating material, they will follow. So then this will qualify to be an originating material.
Okay. Thank you so much. I also believe there were some questions. I think we can ask those questions now. Hello, are we audible?
Yes, you are audible, Nupur. Nupur, there is one question on this calculation. Can you just go back to slide number 21?
Yes.
Yeah, he is just asking the 21. Yes. Let me know the details. How you have calculated non-originating material? That's the question.
So, do you want to know what will be the import value?
Yes.
So, there is a formula prescribed in the rules of origin, which explains what will be the value of non-originating material. It could be either ex works or FOB value. The rules of origin very clearly provide that. In the present illustration, we are treating it as ex works. And effectively, your value of the non-originating material will be the value that you are declaring for the customs purposes, the value at the time of importation.
Nupur, just one question here.
Hmm.
See, when you talk about non-originating materials, you have taken imported zipper, imported interlining, and imported pocketing fabric.
Yes.
Since these are imported, aren't these also non-originating?
Yes, we are treating it as non-originating in this particular illustration.
Then in that case, the non-originating materials become 80 plus 30 plus 8, isn't it?
So it is 128.
Hello, did you hear me, Nupur? Hello?
Point. No, I think
Nupur, are we audible?
no, you're audible. I think there is
Yeah.
a typo error. We have taken 30 and 8 as the non-originating, correct?
38 and then 80 imported pocketing fabric.
Correct? Hmm. So moving to the next slide.
Procedure you explain.
No, we were discussing third country invoicing issue.
So, like we were talking about the other aspects of the rules of origin. Now there are various other points also, like what we mentioned about accumulation, de minimis, accessories. Now, one specifically point we wanted to talk about is with respect to the indirect material. Now, first question is, what does indirect material mean? So, indirect material basically means a material which are used in the production or they are used in the testing of the product, of the commodity. However, they are not physically incorporated into the good or the material. So, an illustration could be in a situation, maybe there are tools, there are dies or molds, which are used to manufacture the finished product which is being exported. So, though it is being used, however, it is not physically incorporated. Now, the question comes whether the value, while I'm calculating the value, whether the indirect materials value will be included or not. So, the answer to this is that under these rules, specifically, it's provided that indirect materials, they will not be considered as originating or they will neither be considered as non-originating for the purpose of calculation of the QBC as
So
specified in the rules.
effectively, does this mean that I don't have to include the value of indirect material when I'm calculating the origin value?
But at the end of the day, while you will be calculating, if you would see the formula use value of the goods.
Okay.
So now the value of the goods, be it X works or be it FOB, I would have always included the value of my value as my cost.
Okay, so it will not be there in the value of originating material or the
Yes,
non-originating
in the
material.
numerator, it's not going to be there. However, in the denominator,
In the total value of the
Yes,
goods, it will be
it
there.
will be there.
Okay.
Yes.
So just for everybody's clarity, I mean, this is also a deviation from some of the past free trade agreements that India has signed into, because typically we have seen that in case of indirect material, the rules of origin very clearly state that the indirect material will also be included as an originating material for the purposes of calculating the originating criteria. However, in this case, they have explicitly stated that it is neither to be included in the value of originating material nor in the value of non-originating material. However, when you are taking the value of the full product, the final product, the indirect material proportionately will fall within that value. In the denominator. Yes, yes. So the next issue that we would like to discuss will be in relation to third country invoicing. And I think this is a very crucial issue for all the parties who intend to claim free trade agreements. So as we understand, let us first understand what is the concept of third country invoicing. It's typically a bill to ship to model where effectively what happens is that the importer will have an agreement with say a supplier A who is located in say for example China, and the supplier in turn will have an agreement with the manufacturer of the good, raise an invoice on the Chinese supplier, and Chinese supplier in turn will raise the invoice on the Indian importer, but the manufacturer in the UK will directly supply the goods to the Indian importer. In such situation, what we have seen in the past is that many a times the customs department in India has raised an issue on the country of origin certificate, and they have expressly denied the country of origin benefit to the assessee by saying that This is a build to ship to model. While the goods are being directly shipped by the producer located in the under the free trade agreement country, the invoicing is from a third party, and therefore FTA benefit will not be allowed because it is not a recognized arrangement under the existing free trade agreements. To plug this loophole, to plug this litigation, because effectively you are satisfying the origin criteria and you should get the free trade agreement benefit. But what happens is that the supplier who's in between, who's supplying the goods to the Indian party, will add his profit margin. And when you file the bill of entry claiming the FTA exemption, you will actually claim the FTA exemption on the value which is charged by the supplier from you. So while the value of the originating product may be 100 rupees, because there is a supplier in between, he is adding his profit margin, etc., the value may go up to 120 rupees. When you file the free trade agreement CO, the exemption is taken on 120 rupees, which is questioned by the customs department. So this is specifically covered in the present free trade agreement, where the agreement expressly allows that third country invoicing is an accepted trade arrangement. And therefore, wherever there is a third country invoicing arrangement, it's a bill to ship to arrangement where the goods are directly being shipped from UK to India, free trade agreement benefit will be available. So effectively, again, this is, when we are dealing with this agreement, we see that there are a lot of measures which are trade facilitation measures which have been taken to, with the intent of ease of doing business. And I think this is a welcome clarification where they have expressly added this provision in the agreement itself, so that there is no problem for the importers or the exporters when they want to claim FTA benefit under the third country invoicing provision. We can move to the next slide.
This we've already discussed. So for all the when we're talking about the rules of origin, for all the products under the textile segment, there are basically dual thing. First is that you have to fulfill the requirement of customs change in the tariff heading, which we called as tariff jump. And second is that you will have to fulfill the value addition criteria. Now, in terms of either build down method or build up method, be consistent in whatever practice you're adopting, but you will have to follow that. Now, just one point I wanted to highlight here is that, like in the introductory discussion, I was telling that earlier, say for ASEAN, the requirement was slightly less stringent. It was just customs tariff change in the tariff headings, that is tariff jump. While as against that, now under the new FTAs, the rules are a little stringent and they have added both the criteria to be fulfilled.
Moving on to the next section. So firstly, let's discuss the proof of origin. Now, to qualify for preferential benefit, one of the documentary proofs that you have to provide to the customs authority is the proof of origin. Now, the criteria is different from the importers in the UK and the importers in India. For importers in India, there are three options available. An origin declaration completed by the exporter or producer. Now, this would mean the Indian exporter's origin declaration that the goods are originating in India. Second would be a certificate of origin issued by the issuing authority. So that would mean you should have the Indian exporter has to submit a certificate of origin to the importer in the UK. Third is the importer's knowledge that the good is originating. For importers in India, while importing something from UK, you will have to provide an applicable proof of origin, which would be an original declaration completed by the exporter in the UK. Now, this origin declaration or the certificate of origin, the validity period is 12 months. Now, this 12 months would be counted from the issuance of the certificate of origin, where the proof is a certificate. Where it's an origin declaration, it will be the date on which the declaration is made to the customs authority.
But just to, one clarification, Preeti. When you say that it could be a self-declaration or it could be a declaration based on the importer's knowledge. Now, this self-declaration or the importer's knowledge will be totally dependent on the information supplied by the exporter, correct?
Correct.
So what does the provision say? I mean, is it important for the importer to get all the information from the exporter in the very beginning when he is applying for the declaration or for the certificate of origin, or he can get this information at a later point of time? What do you suggest? One. Second, whether there is a possibility that to prove the origin criteria, I may ask for figures, etc., which may be confidential information. So, in such a situation, how do I deal with providing this confidential information to my exporter, to the customer?
Right, ma'am. Ma'am, so to answer your first question, it is always prudent that the Indian importers get all the information possible to prove their claim for preferential benefit. This would include, say, a certificate of origin or the manufacturing process undertaken in the UK to prove that they are eligible for preferential treatment. So definitely it is more prudent that you have this information on the get-go.
So are you trying to say that it is important that when I am claiming a preferential agreement and when I am going for a self-declaration or a declaration based on importer's knowledge, then I undertake my own due diligence through maybe third-party consultants or legal consultants, so that I am certain that the information provided to me by my exporter is absolutely correct, and tomorrow the customs is not going to question the origin declaration that I am filing?
Definitely, ma'am. This will also safeguard you from other verification processes that the customs authority may initiate if they doubt the veracity of the information that you've provided.
Understood.
And just as a matter of fact, the rules also specifically provide that whenever you're getting certain goods, you should get the invoice and all the other commercial documents that describe the goods in sufficient detail. So basically, at the time when you are importing the goods, you'll have to be sure that the description which has been given by the exporter and all the other commercial related documents have the requisite details.
Okay. And it is, I think, equally important that the description in all the commercial documents is accurate and is consistent, because it should not happen that I have stated something in the bill of entry. Maybe, I've stated the trade name in the bill of entry, and in my invoice or in my packing list, some other name is mentioned. Then the moment there is a mismatch in the description or mismatch in any of the particulars, it will come within the scrutiny of the customs department. Thanks,
Right,
Disha.
ma'am. And to answer your second question, ma'am, an important feature of the verification process is the protection of confidential business information. So if certain information is considered confidential by the exporter, producer, or the supplier, it need not be disclosed directly. Instead, the exporting country might verify that information and give an intimation to the importing country that the goods are originating.
Okay. So are you saying that the FTA allows the importer, the exporter of goods not to submit confidential information to the importer?
That's right, ma'am.
And perhaps, so as a practical suggestion to everybody here, as a matter of practice, if it comes to a point where there is a verification launched by the customs authorities in India or the customs authorities in the UK, and they are asking for confidential information from your importer, or they are asking for confidential information from you, which relates to which your exporter in the UK is not willing to share with you. One way to provide that information could be either you submit that information through the exporting authority, or alternatively, the information can also be submitted through the legal consultant or the third party consultant who is assisting you during the verification process. In any case, as all of you know, any communication with a legal consultant is a privileged communication, and therefore that information cannot be misused by the authorities at any point of time during the verification or during the stage of issuance of any notice, if it comes to that stage. So therefore, these kind of safeguards one has to build in order to ensure that there is seamless availment of FTA benefit. Second aspect that one needs to see is that, as Preeti pointed out, it is very important that we have the information available with us at the time of filing our Form 1s under the CARDA regulations, or if we are the exporters, we should be sharing the sufficient information with our customer in the UK. This is also for the reason that now the rules of origin have removed the concept of issuing authority vis-a-vis the importers in the UK. So therefore, as a result, whatever information the importer, your customer, needs to provide to claim the FTA benefit has to be provided through you. And therefore, there has to be a seamless exchange of information between you and your customer or your supplier. In many situations, we have seen, sometimes the clients come back and tell us that, this is an information pertaining to 3 years or 4 years, and now we don't enjoy good business relations with our suppliers or our customers. So, to avoid a situation of this nature, it is most important, utmost important that this kind of exercise is undertaken at the very beginning when I'm claiming the FTA benefit, and I keep all the information readily available with me. In fact, the agreement also states that the information should be kept by you for a period of 4 years or as per the time period which is provided in your law. So if I look at the look back period in India, under the Indian customs law, the look back period is 5 years, which means that department can either issue a notice within the 2 year if it's a normal period, and if they want to invoke extended period, they want to invoke suppression, misdeclaration, etc., they can go back up to 5 years. So therefore, this information should be available with you till a period of 5 years, so that if any verification or any any question is raised by the customs on the genuineness of the certificate, you are able to tackle it by yourself.
Now, the next question is if an importer can make a late claim for preferential treatment. Now, in a situation where at the time of import you did not ask for the preferential treatment, but subsequently you realize that you're eligible for that preferential treatment, you may also, the rules of origin explicitly make a provision for late claims for preferential treatment. In such a case, you can also claim refund of any excess duty that you would have paid by virtue of not having claimed the preferential benefit in the first instance.
All right. So maybe just to elaborate here, Preeti, can we not divide this point in two parts? The first situation is where at the time of the export, right, at the time of the export, I did not have a certificate of origin. This could be, say, let's talk about the transshipment cases, that the goods have already reached, it's 15th of July, the goods have already reached UK. And that time we did not have the certificate which was issued by the authority in India. In such a situation, am I eligible to take the benefit today? I think the answer is yes. Right. The answer is yes. You could have taken you are eligible to take the benefit, provided that in the country of origin certificate, you'll have to first get it issued, and specifically it should be written that it's issued retrospectively. So this is specifically for cases which are dealing with the where the goods were they were in transshipment at the time when the agreement came into being. Now this is the first point.
So Disha, I'll take another situation. What if I imported the goods, I had the FTA benefit, the CO available with me, or the declaration from the importer, declaration from the exporter, but unfortunately, due to some reasons, could be the natural calamities, some force majeure clauses, I could not claim the FTA benefit. And the validity of this declaration or the validity of this certificate of origin for the UK importer is over. Then also whether the provision allows me to claim the FTA benefit?
Yes, ma'am. So the provisions allow, provided there are some exceptional cases. So you will have to justify as to why you could not take that benefit within that 12 months time. Now, having said so, I would also want to highlight one point that this is a situation where the period is already over, that 12 months period is over. However, in a situation where the 12 months period is not over, you imported the goods, you had the copy of the certificate of origin, however, you did not take the benefit. In such a situation also, it's not that the law is saying that you're not allowed to do it. However, there are certain time period which you will have to fulfill, and there are certain procedural requirements in terms of the provisions under Section 18A and Section 27 of claiming refund and reassessment that needs to be undertaken to entitle you to avail the benefit subsequently.
So let us see, this is an important point. So for everybody's benefit, we'll elaborate a little on this. Um, what we would like to say is this. So if you have not claimed the FTA benefit within the period of 1 year, because validity of the FTA is 1 year from the completion of the declaration or 1 year from the issuance of the certificate. So issuance of certificate will apply to the importers in the UK. For the importers in India, the self-declaration is the provision that will apply. So in case of declaration, if you have not claimed the FTA benefit as per the declaration and the validity of the declaration period is alive, that is, it is within 1 year, you can go back to the customs authorities. You can perhaps look to file an amendment under Section 149 of the Customs Act, or you may go for an 18A amendment, and which is the provision which allows revision in the bill of entry. And on that basis, you can say that, hey, I had this self-declaration proof of origin with me. On the basis of this proof of origin, now please reassess my bill of entry or amend my bill of entry under 149 and allow me the FTA benefit. This is this is an easy period because it falls within the 1 year timeline, and you claim once your bill of entry is reassessed, you claim the FTA benefit. I will stretch this to a period where my 1 year time limit is over, because as we discussed, the rules of origin, they also help the importers to claim FTA benefit where the validity period of the self-declaration is already over, which means that today I'm going to claim the FTA benefit after an expiry of 1 year. In such a situation, for the importers in India, there will be a bit of an issue, because if I go for a 149 amendment or I go for an 18A revision, both the provisions say that the refund is subject to the time limit of Section 27. Section 27 of the Customs Act says what? It says that you can claim the refund where the duty has been paid without any protest within 1 year from the date of payment of such duty. So therefore, the point that I'm trying to make here is this, that where I know that today I don't have the FTA, or I'm not being able to use the proof of origin, but I will be able to use it at a later point of time, it is very important that while filing the bill of entry, we state that this payment is being made under protest, so that I can come out of that 1 year limitation on the refund, which is applicable from Section 27. Once I say that the duty has been paid under protest, the 1 year time limit will not apply to me, and I can claim the refund at any point of time. The another aspect or the another catch which the importers in India should keep in mind is this, that while you would have paid the duty under protest, you still have not been able to use your self-declaration. In such a situation, what happens? Because almost we are discussing a situation which is beyond 1 year. In such a situation also, if you all recall, there is an old judgment of the Supreme Court of India in case of ITC, where the Supreme Court of India has very clearly stated that to claim refund of any duties, you have to challenge the assessment. That challenge can happen by way of 149 amendment, that challenge can happen by way of filing an appeal, or that challenge can happen by way of 18A revision. Now, in this case, because I could not have used the proof of origin self-declaration, therefore I could not have applied for any of these provisions. As a result, even if you say that it is under protest, you may be in a problem because the 1 year period is over. You could not go for reassessment through any of these routes, and therefore the Customs Department may again come back and say that we are not going to give you the refund. So therefore, this is a very tricky point. And in situations where we have not been able to claim the FTA benefit for whatever reasons, we have to put sufficient checks and balances in place keeping in mind the timelines of section 149, 18A and the appeal provisions, so that, and also ensure that it is paid under protest, so that my refunds are, properly protected. And once I provide the FTA claim, I get the appropriate refund from the customs department.
I'll be covering certain clarifications and advisory that the government had published subsequent to the publication of the agreement. Now, there was a circular accompanied by an IceGate advisory that that kind of operates the rules of origin framework under the India-UK CETA. Now, the India-UK CETA came into force on 15 July 2026, as ma'am pointed out, and introduces an important change in the way preferential tariff benefits are claimed. Now, instead of relying on the traditional certificate of origin issued by the designated authority, as you all know, the agreement adopts a self-certification model. Under this system, the proof of origin is an origin declaration completed by the UK exporter or producer. However, this declaration alone is not enough. Before an importer can claim preferential duty benefits in India, the origin declaration must be authenticated through a mechanism established by the Indian Customs through IceGate. This is the central theme of both the circular and the advisory. Now, this authentication process is completely technology driven. For instance, the UK exporter submits the origin declaration to the designated CBIC email address and simultaneously shares it with the Indian importer through the importer's IceGate registered email ID. Indian Customs will then authenticate the declaration using the exporter's information in the UK. And once this declaration is successfully completed, there is a generation of a unique reference number, in short URN, which will be communicated both to the exporter as well as the importer. The importer can then claim this preferential rate benefit while filing the bill of entry and by quoting this URN on the bill of entry.
So, Preeti, just wanted to ask two questions. First, whether the fact that my preferential claim has been authenticated on the system portal, will it mean that it is verified and therefore I have correctly availed the exemption? Can I, at a later point of time, if the customs comes back to me and says that, we want to verify your origin criteria and we feel that you have not availed the FTA benefit correctly, can I make use of this authentication and say that, no, it was authenticated at that point of time and therefore you cannot come back and question my FTA claim today?
Ma'am, again, so how the advisory and the circular has done it is that they've differentiated authentication and verification.
Okay.
Now, at the time of submission of this information, you will get a URN automatically. However, if the customs authority doubt the veracity of that information, they can of course come and check whether that information that you've provided is correct or not. There is a separate verification procedure that is there. However, the circular merely states that at the time when the information is submitted, the URN will be generated and provided to the importer. So now this URN is your basis to claim that preferential benefit. However, that does not preclude you from certain verification procedures that may be initiated at a later point.
So can I say that therefore authentication on the system portal does not by itself function the genuineness of the origin criteria?
Correct.
Are we audible?
Yes, sir.
Can you finish the PPT and then we can go ahead for a question and answer session? Let
Sure.
the audience ask the question, na?
Okay, sure.
Yeah.
All right. Yes, so now as I mentioned, an important point to remember is that this authentication only establishes that the origin declaration is genuine and has been submitted by a legitimate UK exporter producer. It does not automatically prove that the goods satisfy the rules of origin, and therefore customs authorities may still undertake certain origin verification wherever required. Now, from a practical perspective, importers should ensure that the IceGate registered email address is up to date and correctly shared with the UK suppliers. They should also coordinate with the exporters to ensure that the origin declaration is submitted well before filing the bill of entry so that the URN is available on time.
Now, the advisory also highlights certain common mistakes that can lead to authentication failure, such as incorrect email address of the importer or use of unregistered exporter's email address, missing mandatory information in the declaration, etc. The circular also further clarifies that the validity and use of origin declaration, the timelines which I believe we've already covered. Now, a very useful clarification that has been provided with this circular are for the goods which are in transit under customs control or already warehoused where the agreement comes into force. Now, such goods may still qualify for preferential tariff treatment provided the origin declaration is completed and authenticated after 15th July 2026 and all the prescribed conditions are satisfied. The circular also explains how the URN can be used for warehousing and subsequent ex-bond clearances. Now, overall, the circular lays down the legal and procedural framework, while the advisory provides detailed operational guidance for trade. Together, they establish a trust-based and technology-based system that facilitates trade and authentication procedures that might be initiated by the customs authority after submission of your bill of entry.
Now, thank you, Preeti. Now, we would want to also talk about the new requirement which has come in the form of, we call it as Carota rules. So this has come in terms of Section 28D A of the Customs Act. Now, the Section 28DA was introduced in the Act to enhance the verification process for the preferential rates of duty which an importer is claiming under the trade agreements. The section basically aimed to prevent any trade malpractice or to ensure that only genuine goods are originating from the countries with which India has FTA. They are availing the benefit of the reduced import duties. Now, so what basically Section 28D contemplate is that wherever an importer is making any claim of the preferential rate of duty in terms of any trade agreement, he needs to make a declaration that the goods are qualifying as originating goods for that preferential rate. Now, for that, he has to have sufficient information with regards to the manner in which the country of origin criteria is being fulfilled, the regional value content, what we said standard QVC in this case, the product specific criteria, that is, if we have tariff jump requirements, all those which are specified in the rules of origin in the trade agreement, that needs to be satisfied there, and he needs to possess this information. Now, the reason why he needs to possess this information is because there is, at the time when he is making a claim or subsequently, if the customs officer is of the view that he is not eligible to avail such benefit, in such a situation, he should have those information to give it to the customs officer. So this is what is provided under the Section 28DA of the Customs Act. Now, having said so, this is the procedure which has been given. Now we'll talk about the rules which were given under which is called as Carota rules. Now, as I just mentioned, that this is in terms of these section that these rules had come. Now, the rules also specifically provides that there are certain documents, there are certain compliances which are to be taken by the importer to whenever he is claiming any preferential rate benefit of any preferential rate of duty. So what all things are to be required? So maybe the procedure. Now, the first requirement is that whenever he is making a declaration, he'll first have to explain as to how he is saying that the products are qualifying to be originating goods for availing the benefit of preferential rate. Then in a situation, if they're availing any benefit of any tariff notification, that has to be indicated. The proof of origin covering each item which is there on which the preferential rate of duty is claimed, that is to be there. Now, when I say the proof of origin will have to be is nothing but the certificate of origin. Now, the certificate of origin should have their reference number. They should have the date of issuance. What is the originating criteria? In case if there is any accumulation or accumulation that's applied, all those things are to be there. Now,
specifically for this present FTA, it is important that because the benefit can be availed on the basis of the claim or the certificate of the exporter also. So it has to be ensured that the certificate which is being issued by the exporter, that also has all these details which are required in terms of the compliances under the rules of the Karutar. So this is again an important aspect. It is also covered in the rules of origin. If you see, typically any free trade agreement will provide for a verification process. Similarly, the current India-UK free trade agreement also provides for a verification process. It very clearly states that if the customs authority of the concerned country questions the genuineness of the certificate of origin, it will ask for the information from the importer on record. So therefore, if the goods are being exported from India, the customs authority in UK questions the genuineness of that certificate, it will ask for the information from the importer in the UK. Of course, the importer in turn will rely on the exporter, or in case the exporter is a third party and the goods are produced by some other person, then the exporter in turn will rely on the producer for the information, and this information has to be provided to the exporter in the UK. If the customs authority is satisfied after receiving the information, matter ends there. Of course, the FTA benefit is given. However, if the customs authority is not satisfied and the customs authority further wants to probe, then it can approach the exporting authority of the country, which is India, for the purposes of getting additional information on the certificate of origin, which is issued by the Indian authority. Similar mechanism is available for the Customs Department in India, where the customs authorities in India will question the Indian importers. The Indian importers, if they fail to provide the information, then the verification process will be launched with the exporting authority, which will be HMRC in this case. HMRC will in turn get the information and submit it to the customs authority in India. On that basis, the verification process will be completed by the Customs Department in India. In case the information is not submitted by the exporting authority, or the customs authority still believes that they do not approve with the information submitted, and they still think that the genuineness of the certificate of origin can be questioned, they may look to reject, suspend the claim till the time the information is pending, or on the basis of information, they may say that we are not satisfied with the information, and they may reject the FTA claim and proceed to issue a show cause notice under Section 28 of the Customs Act to the importer in India. So therefore, the whole purpose of bringing in this mechanism of Section 28 DA, while it was there in the rules of origin, in the verification rules of origin, and there are verification procedures in different rules of origin under different FTAs, the government still explicitly brought this provision under the Customs Act, because in the past, when the certificates of origin were questioned by the Indian Customs Department, the courts took a view that the Customs Department does not have powers to go beyond the certificate of origin. It was effectively to take care of this particular, legal jurisprudence that Section 28 DA was inserted, and now it gives extraneous powers to the Customs Department, who, along with Section 28 DA, read with the verification procedure prescribed under the rules of origin of different FTAs, can launch verification on the exporter in the other country. One aspect which again all of you should remember is that it is very important, while the provision is there and the Customs Department has the powers to launch a verification, the verification has to be launched as per the procedure prescribed under the rules of origin, under the India-UK FTA rules of origin. So therefore, if the Customs Department is not following the due process of law, that verification can be questioned on the ground that the procedures have not been followed properly. Just to give an example, they may ask the importer for all the information. they may say that the importer is required to provide the confidential information. They may not wait for the response that the importer is waiting for the exporter to provide to him. They may say that no, we are not going to wait further and we are going to suspend your FTA claim or deny your FTA claim. In such situations, as an argument, the importers can very well plead before the courts that the verification process was not properly followed, sufficient time was not given to the Indian importer, and therefore such rejection or such suspension of FTA claim is outrightly legally incorrect. So we can take those kind of arguments. Of course, it will depend on facts and circumstances of each case. And but verification is a very crucial aspect. And therefore, the sum and substance of the current FTA is that, yes, while there is a lot of ease of doing business, there are a lot of trade facilitation measures introduced, but it also creates an equal amount of compliance or responsibility on the concerned importers and exporters. And if we want that there should be a smooth flow of free trade agreement benefit under the India-UK FTA, then there has to be a seamless exchange of information between us and our suppliers and exporters. And we should be always ready to provide the relevant information to the authorities. So all of this we've covered. I think now we can move to question and answer.
Good evening. This is from Pratishta, Coimbatore. Can you hear me?
Yeah, we can hear you.
Sir, from which where we can apply for this certificate of origin, whether from the inspection agencies or the FIO? Can you inform the place and address?
Sir, preferential certificate of origin can be applied through Trade Connect platform, and the agencies are DGFT, Export Inspection Council, and Textile Committee is also there. Textile Commissioner.
So there are
Textile
basically
Commissioner. No, can you please
under the. Are you able to hear me first?
Yes.
Are you able to hear
Yes,
me?
Preeti.
Yes, madam. Go
Yes,
ahead.
Preeti, we can hear you.
Hello. Yes, madam. Sir, it's a textile committee or textile commissioner office?
It's Textile Commissioner Office.
Hello. Am I audible?
Yes, Preeti, you are audible.
So only 2 agencies we can apply, sir. Export inspection.
Sorry, are you audible now?
Yes, Preeti, you are very much audible.
So I understand your question was what is the appropriate time to apply the rules of
To
origin?
whom we can apply and when?
To whom we can apply and when. So at the time of import, one of the
Preeti,
criteria.
the question is different. He is asking which are the agencies from which they can apply for preferential certificate of origin.
So for the UK, the appropriate authority would be the HMRC, which is their revenue department in the UK. For India, it would be the CBIC,
CBI.
Customs Department.
Customs Department.
So the DGFT and they have also appointed some authorities, the export control councils, to whom you can apply for the rules of origin.
Yeah, that's what I'm asking. Who are the agencies? As
So we just share the names
settlement.
with you.
Sir, you can apply through Trade Connect platform and select DGFT, Export Inspection Council, Regional Authority,
Yes.
and Textile Commissioner Office.
Okay. As we are going for this India South of
Textile Committee
South
also
Korea
accepted.
agreement, like.
India,
Okay.
yes.
Textile Committee also accepted.
So the full
Yes.
form is Export Inspection Council and Export Inspection Agencies. These are the ones which have been notified under for the purposes of getting the certificate of origin.
Can you repeat, madam?
Sir, Export Inspection Council, EIC.
Okay.
We'll share the details, sir. We'll do it separately.
You mean export inspection agencies and textile committee are authorized to issue preferential certificate of origin, right?
Certificate of origin, sir. Certificate of origin.
Yeah, certificate of origin.
Yes, sir. And
Not
also,
textile.
apart from that, so one is certificate of origin. Otherwise, for the importers in the UK, even a declaration, original declaration from the exporter or the producer, which is in India, that will also do.
We are an exporter. I'm asking only for export goods.
Okay, sir. Okay.
So I can apply with textile committee, not the commissioner, right?
Yes, sir. There are specific. Yes, sir. Committee. The like I mentioned, the name specifically export promotion. That's the one.
And there is any inspection before the shipment for getting this preferential certificate of origin?
So you will have to, each certificate of origin is consignment specific. While you are making an application for to the certifying authority, you will have to give all the details with respect to the, say, in case if it's tariff jump or in case of value, all those details will have to be given. They're going to see whether the requisite conditions or requisite criteria are being fulfilled, and on that basis, the certificate is going to be given to you.
I'm asking you whether there is any physical inspection
Not necessarily. They will go on the basis of information that you have provided.
However, in a situation where they feel that maybe the details are not correct, so on the basis of the past experience, say for example, you are showing some product to be originating in India when it is not being manufactured or produced in India at all. So in such a situation, there is a where they doubt the veracity of the information which is given in order to get the certificate, then they can of course go and physically check.
Otherwise, it's application based only.
Okay, thank you.
Yeah, Preeti, can you just check the chat box? There are some questions in that, and then you can just read it and then answer it.
So with respect to the, I'm taking the question of Brijlalji. See, what documents you'll have to upload when you are applying. You would have to apply the details with respect to whatever inputs you have availed or whatever inputs you have used in order to manufacture the finished products. Put all the information which is required in order to ascertain the value addition criteria as well as in terms of tariff jump. Because your product it falls under the product specific rules and both are required. So then you'll have to put all these documents will have to be uploaded. Then
Nupur, if I may come in here.
Sorry.
Nupur, if I may come in here.
Yes.
I think let's assume Mr. Brijlal's query once again. So suppose if he is probably making the ready-made ladies garment, if he's using the yarn, fabric, everything within India. So I'm assuming that this is his question. So what does he file it under, WO or produced entirely or PSR?
So it depends upon the inputs, sir. In case if the inputs are those which are manufactured using Indian grown yarn, Indian grown cotton, then of course it's going to be wholly obtained, no? However, in case if there are certain products which are also taken from some other country, like say for example China, in that situation it is going to, then it will have to come in the third category, which is using non-originating goods as well.
So
But generally,
wholly owned will be where wholly obtained will be where your raw material is entirely produced in India. For example, cotton. But if I am using synthetic fabrics, or I am also using other material which is not produced, rather it could be domestically procured or it is obtained from outside India, then that wholly obtained criteria will not apply.
Well, and in a situation where it is produced using only originating materials of a country, then it's going to come in the second category of produced entirely. So there are three criteria, sir. If I may just explain it again. One is wholly obtained, which is for minerals, for whatever is grown from the soil, animal products. That's wholly obtained. The second criteria is
produced entirely in the territory. So this is produced exclusively from the goods which are originating in India or originating in UK. That's the second category. The third category is where you have used non-originating products also, but you're fulfilling the value addition or the tariff jump as the case may be. The products
So
that.
in this case,
So
so
we
in
have
this
to
case, so in this case, if he's making the ready-made ladies' garments entirely in India, then PE is the correct choice for him.
produce entirely. Correct, absolutely.
I hope your question has been answered, Mr. Brijlal.
It's not there.
No, he's on mute. You're on mute, Mr. Brijlal. Okay. Okay, we can move on to the next question.
Now, then there's one question of Mr. Khurana, Sanjeev Khurana, where he's saying that in his case, the container has left Nhava Sheva on 12th July and the FTA got implemented on the 15th of July. Now, there are two manners in which this can be done. Either a certificate can be issued and on that basis, the benefit can be availed, or a certificate of origin can be issued retrospectively. So, you can approach the certifying authority in India, ask them for retrospective issuance of the certificate of origin. The certificate will read as issued retrospectively, and you will be eligible to take claim the benefit of FTA. So is your question answered?
Mr. Khurana, are you there?
We can move to the next question. In case anybody has any follow-up questions, you can definitely write back to us. We'll be happy to answer your questions. So the next question is of Mr. Rajiv Nenwal. He has asked, what is the producer in the certificate? Is it manufacturer or is it manufacturer of the goods? So in the certificate of origin also, there's specific column for producer. This is basically the goods which are produced. And the second is manufactured. So wherever there is activity which is to be manufacturer. So that's the distinction. And the other distinction is that in a situation where the manufacturer is not the exporter, then you will have to put both the details. Any other person, because a third party can also be exporting the goods. Yeah.
Hey, I'm audible to you.
Yes.
Actually, I have a question. If you're importing anything under FTA from UK and the profit is zero, are we able to claim DBK or not?
How can we determine the fabric?
So can you repeat the question? We didn't hear it.
I'm saying if we are importing anything under FTA with from UK and the preparation rate is zero, right? So are we able to claim DBK or not on that?
What is zero? Ma'am, what is zero in your question?
BCD rate is zero for that product. So am I able to claim the BCD or sorry, DBK on that or not?
Drawback on the exported goods. Drawback. So what you are saying is you will import a product under zero duty, and then you will use it for manufacturing finished goods. When you export the finished goods, you want to claim drawback.
Yeah. Am I able to or not? That is my question.
Ma'am, you will have to go for. I'm taking the situation where most of your inputs are subject to zero BCD. And perhaps you would have paid some IGST, or you would not have paid IGST at all, or there could be some BCD exposure. But in such situations, you have to go for brand rate, because you are not subjecting all your goods to all your goods are not subject to BCD. So we can discuss this offline. We can go. Drawback is definitely available. We'll have to assess whether I have to go for branded or AIC.
One second, Nupur. Drawback cannot be entitled because drawback is nothing but the custom duty which is paid on imported material. If she is not paying
it is an average of duties.
Available.
That's why I said that we will have to go for brand rate, because I will have to understand in detail whether there is any duty at all, because it cannot happen that all your inputs are zero rated. There will be some input where, and again, your FTA will only exempt your BCD, or FTA will not exempt your IGST. That is another aspect to be seen. So therefore, drawback can be fixed on the brand rate basis.
I think there is a question from Romil Shah.
No,
Romil कहाँ है ना? Yes. Yeah, Nupur, there is one more question from Mr. Romil Shah. You mentioned self-declaration will suffice from Indian exporters. Does that mean statement only on our letterhead and signed by us saying goods are made in India? No need to go to any DGFT or EI office?
Not really, sir. So you'll have to fulfill all the or your certification should include all the details which are required in the certificate of origin also, read with the what's required under the Carota rules. So all those will have to be added. It's not just a simple certificate saying that I certify that the goods are Indian origin. That would not be sufficient. You will have to give all the backup documents as well as details. Correct. So if there is a tariff jump, you will have to show how there is a tariff jump. If there is, you will have to show how you are satisfying the value addition. Are you following build-up method? Are you following build-down method? You will have to show that these are the inputs you've used. This is how you've achieved the origin criteria. So all of that information has to be given because in fact, we are displaying the information that is required. The origin declaration, it states everything. This is what you are required to submit. Annexure B of the rules of origin. You may see it, and in case you have any further queries, you may let us know. It is Annexure B of the rules of origin. It is which were notified in July.
Is there any format, ma'am, for showcasing what is the costing that you have taken into and how you have arrived at the the value addition, etc.? Is there any particular format?
The formula is there, no, sir? You'll have to use the formula which is given. So put all the details only the annexure and the formula. Yes.
Okay.
The annexure we are already displaying such like an application which covers everything. So we have to give this origin declaration. And on the basis of this origin declaration, if any further information is requested by the corresponding customs department, then we'll have to submit that information. Of course, keeping in mind the fact that confidential information need not be submitted.
There seems to be one more question on the same thing which is on the screen. What is the roll-up and what is the meaning of bottling?
Sorry, where's the question? We can't see the question. I'm sorry.
It's by admin. What is the roll-up and what is the meaning of bottling? I think it's the last question perhaps which is there on the chat.
What is the roll-up? What is the meaning of bottling?
Here it also means here in that form.
In the same format which is shown on the screen at point number 10, there is something called as roll-up.
So we'll have to understand bottling definitely relates to packaging, but I would want to know the specific query. I mean, when they say what is roll-up, what is bottling, what is the operations that they are undertaking?
Because the rules is not specifically for textiles. It also has for wines and for
Correct.
scotch. So
Correct.
bottling basically would mean that in case if you're getting certain concentrate and then you're converting into diluting it to make it ready to drink alcohol. So I think bottling is in that respect.
Okay.
So it's a general rule of origin. It covers all the industries and not specifically for textile.
Oh, it's fine.
So we also saw a question. We got a CO from HMRC UK. This will fulfill to get the duty benefit for importers.
Yeah.
So just the certificate of origin would not suffice.
So this question is coming from I'm assuming from an importer who is importing the goods in India, correct? Because they're saying we have a CO from HMRC. For the importers in India, the certificate of origin from HMRC is not going to work. You actually require a self-declaration from the exporter of the goods. That's the correct document for claiming the FTA benefit. So as Preeti had explained in the beginning, for the importers, it is the self-declaration for the importers in India. It is the self-declaration from the exporter of the goods, and exporter or producer of goods in case the producer is a different entity. The CO from the issuing authority is applicable when the exporters are exporting the goods from India. So effectively, there are 3-4 types of declarations that can be submitted.
There is another question from the Textiles Committee in Karur, which says that we use linen often, which is locally sourced. However, its origin is from Belgium. So how is this scenario to be considered?
So there is a specific rule, that's Rule 7, that specifically provides that in a situation where you are using certain non-originating products and you are undertaking certain manufacturing on them or certain other activities are being undertaken, that they fulfill the requirements of this rule, and using that a finished product is made, then it will qualify to be an originating product. So at 2 levels, you will have to look at the origination criteria. First is at the level of that input. Second is at the level of that finished product.
Madam, in this regard, can I ask one question? The linen yarn is imported and yarn is manufactured in India, and we weave the fabric and stitching the mirrors and exporting. So it is, we are eligible for this certificate of origin?
Yes.
So in that situation, you'll have to give us more details here with respect to the activities which you are undertaking, the value attributed to all the activities, the other inputs which you are getting, the local procurement, what is the cost of it. All those criteria or all those details will have to be seen to ascertain whether it's qualifying to be originating or not.
So the law is very clear. The law says that if you are importing a non-originating material, that non-originating material is processed in India and you make an intermediate product out of it. And from that intermediate product, you make the finished product. If the intermediate product is satisfying the originating criteria, it will be treated as originating. So there is no doubt there. But we will have to apply the formula to your set of facts, to your set of goods, to see what all have you imported, what all are the activities undertaken by you, to see whether your intermediate product is meeting the originating criteria. Legal principle is this: you apply the legal principle to your facts, and if you are then satisfying the origin criteria, then you go and treat it as originating in India.
Okay.
So I think with that, I think we can end today's session. And in case there are any further queries, we will be happy to take them offline. No problem at all.
Yeah, thank you, Nupur. But before we hand over the session to Mr. Deepak Mukhi, I would like my colleague to make some announcements. So Shailesh, over to you.
Yeah, so
Please mute yourself.
So just a few announcements regarding the forthcoming webinars which the Council is organizing in the month of August. On 12th of August, we have India-Russia ruble trade. We have the webinar on the India-Russia ruble trade, which is on 12th of August, and that will be very interesting for people who are already exporting to Russia or are interested in exporting to Russia. On 18th August, we have got a webinar on the interest subvention scheme under the Export Promotion Mission. That will be held on the 18th of August. And on the 25th and 26th of August, we have the generative AI for textile exports, which will be held at Hotel Orchid. Those who are interested in registering for this program may kindly get in touch with the council at the earliest so that we can register your name. So these are the 3 important webinars and activities that we have for this month. And exporters who are on this forum who are interested in being a part of either of these programs may kindly register or get in touch with the council so that they may take benefit of attending these programs. I will now hand over the session to Mr. Deepak Mukhi for his concluding comments.
Hello, good evening, everyone. Thank you very much. I think this was a very extensively, sort of covered program just for textile sector. So on behalf of FICCI and textile, TEXPROCIL, I would like to really thank our expert, speakers, Nupur ji, Disha ji, Priti, for, sharing all what is currently on offer under the India-UK, CETA, which is obviously evolving, and there will be a lot of questions and queries. But I think in this presentation, it was very well and vastly covered, be it rules of origin, proof of origin, or clarification given by GOIs on whether what are the obligations of the importers or exporters, what kind of verifications are required. So I think a lot of things have been covered. A basic set is being given, and as all the expert speakers said, that if you are looking at having any specific query, I think do write to them, so they would be able to sort of help you out with a better understanding of where the challenge is there. And obviously, this would not be possible. The engagement, the level of engagement would not be possible with the support of all the delegates who participated, both members of TEXPROCIL, FICCI, and textile industry at large. We recently actually visited under the Commerce Minister's delegation. About 160 plus companies have actually gone to London, and we could see the excitement under that partnership, which is evolving, continuously evolving. And I'm sure textile being one of the, as suggested by a speaker, one of the larger contributor would play a big role in terms of increasing our export and bilateral trade with the with UK. So thank you very much to all the delegates also for participating, and obviously thank you to the organizing team of TEXPROCIL, Mr. Praful out there, and Dr. Rajgopal in the morning, sort of afternoon, gave the opening remarks. So thank you everyone for being there. I think a lot of webinars have been talked about. Similarly, FICCI would also be organizing multiple webinars and physical programs, which I think my colleague Pradeep will share detail as and when they get finalized under the schemes of various promotional seminars being done to promote both UK as well as EU CETA. So thank you very much, and look forward to having your continued support and participation for our future programs as well. Have a wonderful day.
Thank you, Mr. Deepak. Thank you, Pradeep. Thanks a lot, participants. Thank you so much, Nupur and Disha. Thanks a lot.
Thank you.